अच्छा जी। हम्म। काफी खामोशी रह गई है।
दिखाइए ऑर्डर, फाइल दिखाइए, फाइल दिखाइए। हाँ, क्या है, क्या मैटर है आपका?
Sir, it is with regard to the termination of the contract of sand,
हाँ,
and the recovery has been issued.
नाउ यू
Not
शो
in
मी द
person.
ऑर्डर ऑफ टर्मिनेशन।
Sir, sir,
वेयर इज योर टर्मिनेशन?
it is annexure P1, sir.
हाँ, रीड द ऑर्डर।
Sir,
रीड द ऑर्डर।
sir. मैसर्स विजय बिल्डर्स ग्राम ब्यावरा जिला गार्ग के पक्ष में गुना जिला समूह की रेत खदानों का वार्षिक ठेकाधन 2,75,99 पर दिनांक 5/6/2020 को अनुबंध किया गया था। मध्य प्रदेश राज्य खनिज निगम द्वारा मैसर्स विजय बिल्डर्स को जिला गुना में स्वीकृत रेत समूह की खदानों के संबंध में माह मार्च, अप्रैल और मई 2022 की देय राशि 71,08,640 राहत राशि सहित ब्याज, पेनल्टी, टीसीएस अतिरिक्त जमा न करने के आधार पर मध्य प्रदेश रेत नियम के 15(1) के अनुसार नोटिस जारी किए गए। प्रकरण में मध्य प्रदेश खनिज निगम द्वारा रेत ठेकेदार को माह मार्च, अप्रैल और मई 2020 की देय राशि जमा न करने के आधार पर जारी नोटिस दिनांक 27/5/2000 के आधार पर प्रकरण पर निराकरण किए जाने हेतु रेत ठेकेदार को सुनवाई का अवसर प्रदान करने हेतु 22/4/22 को सुनवाई नियत की गई। नियत सुनवाई में मैसर्स श्री विजय बिल्डर्स की ओर से पुष्पेंद्र सिंह उपस्थित हुए। उनके द्वारा मौखिक रूप से अपना पक्ष समर्थन किया गया। बकाया राशि जमा की हेतु समय प्रदान करने के लिए लिखित आवेदन प्रस्तुत किया गया। उनके अनुरोध को मान्य करते हुए उन्हें समय प्रदान करते हुए प्रकरण में आगामी सुनवाई तिथि 4/5/22 समक्ष में नोट कराई जाकर सुनवाई हेतु आरित किया गया। नियत सुनवाई तिथि 4/5/22 को रेत ठेकेदार ना तो स्वयं उपस्थित हुआ, ना ही उनका कोई प्रतिनिधि उपस्थित हुआ। सुनवाई तिथि 4/5/22 में अनुपस्थिति के संदर्भ में ना ही उनका कोई आवेदन सूचना आदि दी गई, जिसके पश्चात प्रकरण में आगामी सुनवाई तिथि 18/5/22 नियत की। सुनवाई दिनांक 18/8/22 को रेत ठेकेदार पुनः उपस्थित रहे। प्रकरण में सुनवाई दिनांक 20/5/22 को नियत की गई। नियत सुनवाई के संदर्भ में रेत ठेकेदार का आवेदन प्राप्त हुआ, जिसमें उनके द्वारा बकाया राशि जमा किए जाने हेतु समय चाहा गया। उनके अनुरोध को मान करते हुए प्रकरण में आगामी सुनवाई तिथि 6/6/22 नियत की गई। नियत सुनवाई तिथि 6/6/22 को रेत ठेकेदार तो ना तो स्वयं उपस्थित हुए, ना ही उनका प्रतिनिधि उपस्थित हुआ। सुनवाई तिथि 6/6/22 में अनुपस्थिति के संदर्भ में ना ही उनका कोई आवेदन सूचना आदि दी गई। मध्य प्रदेश खनिज निगम की ओर से प्रकरण में पक्ष समर्थन करते हुए कहा गया कि ठेकेदार पर मई 2022 की स्थिति में शासन की बकाया राशि रुपए 71,08,640 है, जिसे रेत ठेकेदार से नियमानुसार विलंबित ब्याज सहित जमा कराए जाने हेतु आदेश जारी किए जाने का अनुरोध किया। प्रकरण से संबंधित समस्त अभिलेखों एवं संधारित पत्रों का अवलोकन किया गया। परीक्षण उपरांत निम्नानुसार स्थिति है। रेत नियम 2019 के नियम 12 में प्रावधान है कि रेत खदान के संचालन हेतु समस्त वैधानिक अनुमतियां ठेकेदार द्वारा प्राप्त की जाएंगी। रेत नियम 2019 के नियम 10(3) सर, दिस इज रेलिवेंट 10(3) सर, आई एम चैलेंजिंग द वायरस ऑफ दिस। 10(3) में यह स्पष्ट प्रावधान है कि समूह में सम्मिलित किसी भी एक या एक से अधिक खदान की वैधानिक अनुमति प्राप्त हो करने के पश्चात खनन संक्रियाएं प्रारंभ करने पर समूह का समस्त वार्षिक ठेका दर तय होगा। अतः इस आधार पर भी यह तर्क मान्य योग्य नहीं है कि ठेकेदार को कुछ ही खदानों को संचालन का अवसर मिला था। यह ठेकेदार की जिम्मेदारी थी कि वे आवश्यक वैधानिक अनुमतियां प्राप्त करते और तदनुसार रेत ठेका संचालित करते। रेत नियम 2019 के नियम 9 में यह स्पष्ट प्रावधान है कि ठेका की अवधि 3 वर्ष होगी, जिसके प्रथम वर्ष की गणना अनुबंध की तारीख से वर्ष के 30 जून तक की होगी। इसी प्रकार नियम 10 में यह प्रावधान है कि ठेके के द्वितीय वर्ष, सर दिस इज ऑल्सो वायरस हैज बीन चैलेंज सर, 10 में यह प्रावधान है कि ठेके के द्वितीय वर्ष या तृतीय वर्ष में वार्षिक ठेका राशि से 10% अधिक राशि का ठेकाधन लिया जाएगा। इसके आधार पर नियमानुसार ठेकाधन में 10% की वृद्धि की गई है सर। नाउ सर, ऑन द बेसिस ऑफ दिस, in pursuance to the rule 10 of the sand rules, which has been framed under the powers conferred by section 15, section 23, read with section 9b of the Mines and Minerals Development and Regulation Act 1957. Sir, what rule 10 says, sir? It says, sir, fixation and payment of the contract amount, sir. The highest amount received in the tender shall be the annual contract amount, and in the first year of the contract, the annual contract amount shall be payable only. In the second and third year of the contract, 10% more than the annual contract shall be paid. Sir, this rule, this condition which has been raised under 10 subclause 1 goes contrary to rule 15(3) of the act. It says, sir, may I read, sir? Rule 15(3) of Sir Mines and Minerals Development and Regulation Act 1957, sir. Sir, the power of the state government to make rules in respect of the mine and mineral. Sir, under this, the power has been granted, but the subclause 3 says the holder of a mining lease or any other mineral concession granted under any rule under subsection 1 shall pay royalty or dead rent, whichever is more, in respect of the minor minerals removed or consumed by him or by his agent, manager, employee, contractor or subleasing, at the rate specified for the time being in the rules framed by the state government in respect of the minor minerals. So proviso is very specific, provided that the state government shall not enhance the rate of royalty or dead rent in respect of any minor minerals for more than once during any period of 3 years. They say, sir, that the 10% will be enhanced every year, the second year.
तो उनको जो कॉन्ट्रैक्ट मिला है खदान का, उसमें पहले साल जो राशि है उसके बाद सब्सिक्वेंट या अगले सालों में उसमें 10% की बढ़ोतरी होने की बात कही गई है, जो कि उन्होंने कहा कि वो एक्ट के ही खिलाफ है। और फिर एक्ट को पढ़ के सुनाया कि उसमें यह है कि एक समान ही राशि ली जाएगी। आइए देखते हैं।
Here in the consecutive third year. Thereafter, sir, I am challenging also the 10 subclause 3, sir, of the said rules, sir, which says the whole annual contract money for the group shall be payable on commencing mining operation in one or more quarry included in the group after getting statutory permission. This also goes contrary to, sir, rule 15.3, which says he will be required, any person or his agent will be required to make the payment for the purpose whatever he has been excavated. They say if at all you have initiated a mining at one point of,
तो इसमें यह है कि जो आप राशि देंगे वो दे देंगे और बाकी कागजात लेना आपकी जिम्मेदारी है। वो अगर मान लीजिए जो स्टेटूटरी जितनी भी परमिशंस लेना है वो नहीं ले पाए तब भी वो राशि देना पड़ेगी। मगर एक्ट कहता है कि आप यानी कि ठेकेदार या कोई भी एजेंसी वो पे करेगी जितना वो निकालेगी एक्सकवेशन के विरुद्ध। तो ये दो चीजें चैलेंज हो रही हैं इसमें, वकील साहब के
at one mine you have to pay the royalty for whole of the mine, sir. And sir, I am also challenging rule 2012.5. 12 subclause 5 says the annual contract amount shall not be reduced in any case if there is reduction in mineable quantity in approved mining plan. Environmental clearances, what means, sir, nothing can be reduced in spite of the fact that I was not able to permit it for excavation because only for the 3 months I could not have paid that rent. Otherwise, since 2020 I am consistently paying. Now this aspect has been considered by the coordinate bench, and upon the same, sir, may I? Sir, may I read? The primary contention of the petitioner is that Rule 12 subclause 5 of the Madhya Pradesh Sand Mining Transportation Storage and Trading Rules 2019 is contrary to Section 15 subclause 3 of the Mines and Minerals Development and Regulation Act 1957. That in terms whereof show cause notices have been issued for recovery from the petitioner, it is further submitted that an order appears to have been passed by the respondent state terminating the contract of the petitioner. Hence, it is pleaded that the respondents be restrained from taking any coercive action against the petitioner. The learned Advocate General submits that the presently an order terminating the contract has been issued on 31/12/21, that the same has not been challenged in this petition and therefore no relief could be granted. That show cause notices were already qua the subject matter in WP 25983 of 21 and therefore such a prayer cannot be granted herein. Until and unless the termination of contract is challenged, no consequential orders could be granted. He further pleads that since the constitutional validity has been questioned, the same requires to be answered by the state, for which appropriate time can be granted to him to oppose the same. On hearing the learned counsels, we are of the prima facie view that the provisions of Rule 12 subclause 5 may not be in consonance with the Section 15 subclause 3 of the Mines and Minerals Development and Regulation Act 1957. Prima facie it appears to be erroneous. However, the same will be considered only after considering the objections to be filed by the state. Presently, we take notice of the fact that the contract of the petitioner has been terminated, as a consequence whereof the state is entitled to initiate proceedings of recovery and other related issues. Therefore, we are of the view that when the validity of the rule is under question, it is not only just and proper to ensure that appropriate protection be granted to the petitioner, but also that no steps be taken by the state that would frustrate the present petition. For all these reasons, the state is directed not to initiate any proceedings against the petitioner in relation to the contract in question.
That's all.
Sir, this has further been considered by the coordinate bench, sir.
और कोऑर्डिनेट बेंच द्वारा जो कही गई बात ये अभी हमने सुनी, तो इनका मामला पेचीदा यूं है कि इन्होंने जो बारीकियां हमने भी पहले ब्रेक में बात करी थी, उनके आधार पे इन्होंने अमाउंट कम पे की। सरकार ने उसको आधार बना के इनके खिलाफ रिकवरी निकाली और अंत में जाके इनका कॉन्ट्रैक्ट टर्मिनेट कर दिया। अब ये कोर्ट में है,
In
चल रही है सुनवाई।
subsequent decision upon the same point, sir.
One order is sufficient.
Sir,
Anything else?
sir, that's what. So what I request your lordship, sir, that once they do not, I may be wrong. And one more particular thing, sir. Sir, what the NIT says, your lordship may be pleased to see the sir. Just a moment. I will not take more than 1 minute.
No, you take the whole day, no
No,
problem.
sir. Just 1 minute, sir. Sir,
Because you are right to argue.
no, sir. It is your sir. Your lordship has considered me. That is a very
No, you have
because
right
now
to
it is
argue.
live, sir. Everything, everybody will see and will say that you have not even argued.
No, you are arguing the matter. And we are hearing you also.
Thank
And we gave you second hearing also.
That's.
And without full stop comma, you are arguing. There is no problem.
I'm
As
sorry,
regards
sir.
the argument.
I must not have.
No, you have argued to the best of your ability.
Sir.
Who says that you have not argued?
Sir,
The whole audience is seeing you are arguing the matter.
No, sir. Your lordship may kindly peruse to page 34, sir. If your lordship.
You are without caring whether the court has seen the documents or not. You are without full stop comma. You are arguing.
Oh, I'm so sorry.
Most apt way of argument.
That is there. That must be there.
No,
sir.
no,
I am
no,
sorry,
no,
but I do
naturally.
not know.
No, no.
I may be wrong, sir.
No,
But
why you should say you are wrong?
बिना रुके नॉन स्टॉप जो वो अपनी बात बोलते गए, उसके ऊपर कमेंट है जज साहब का कि बिना कॉमा फुल स्टॉप के आप लगातार बोलते रहे। और बस इतना ही कह
Maybe
You
wrong,
are
but sir, I
absolutely-
appreciate that
you-
your lordships being seniors to me will ignore my faults, sir. That
No,
is
no,
what
I am not there to ignore or accept the fault. I am only here to hear your argument. We have accepted you have heard your argument. Now further you want to argue?
Sir, just a moment, sir. If your
Ah.
lordship. Sir, your lordship may be pleased to peruse the page 34, sir.
Yes.
सर सर सेकंड पैरा सर, परंतु यह कि किस्त जमा करने की निर्धारित तारीख से 30 दिवस के भीतर ठेकेदार द्वारा उक्त कारण बताओ नोटिस का जवाब देते हुए विलंब अवधि पर 24% वार्षिक की दर से ब्याज सहित देय किस्तों का भुगतान करने पर कलेक्टर द्वारा खदान का संचालन किए जाने की अनुमति दी जा सकेगी। परंतु यह और कि 30 दिवस की अवधि के भीतर उपरोक्त अनुसार यदि ठेकेदार राशि जमा करने में असफल रहता है तो कलेक्टर द्वारा ठेका व्यपगत आदेश कर पुनः निविदा हेतु शासन को अनुरोध किया जाएगा। निविदा की विज्ञप्ति प्रकाशन के पूर्व तक ठेकेदार समस्त देयताएं 24% वार्षिक ब्याज के साथ जमा कर सकता है। नवीन निविदा विज्ञप्ति प्रकाशन पर स्वमेव ठेका पूर्ण से निरस्त समझा जाएगा। सर, इन द प्रेजेंट मैटर अप टिल नाउ द नोटिस द NIT has not been issued. I am ready and willing, and before your lordship I am ready with the amount. If your lordship may
You deposit the amount which you have agreed to deposit.
sir, I can your lordship may take it on record. I can give the check right away to the state.
No, you first deposit the amount which you have decided, you have agreed to deposit and then defaulted in appearing before the court, before the authority.
Sir, that is what I am suggesting.
How much is the amount?
Sir, it was 74 lakh. And now what has happened, sir? Your lordship may be pleased to see annexure P2. What is the stringency, sir? Now, while P2, your lordship may be pleased to see the annexure date of annexure P1, sir. It is dated 13/6/2022.
Whatever is the due amount, you
Sir,
pay first.
that is what I am submitting, sir. If your lordship may kindly consider P1 का डेट देख लें सर।
1,74,99,838.
लॉर्डशिप इसका डेट तो देख लें सर। एक मिनट, मेरा एक सबमिशन सर। ये डेट है सर 14/7/2022 सर। दैट इज अ कॉन्सिक्वेंशियल ऑर्डर इन परसुएंस टू एनेक्चर P1 व्हिच इज डेटेड 13/6, जस्ट 1 मंथ बिफोर। सर 1 मंथ बिफोर उसका रिकवरी रेशो था 71,08,640 इंक्लूडिंग नियमानुसार विलंबित ब्याज सहित जमा कराया जाकर वसूल किया जाए।
Mr. Counsel, if you want our interference,
Sir.
first you deposit revenue, this will always be subject to the final outcome.
सर फुल 170
Yes,
सर,
sir.
but that is
See,
not in
question here is,
आप जमा कर दीजिए, फिर फाइनल हियरिंग में जो भी होगा उसके हिसाब से वो हो जाएगा, मतलब एडजस्टमेंट वगैरह, ये मैं आशा निकाल रहा हूँ। और मगर आपको सबसे पहले जो कही गई है वो राशि जमा करनी होगी, तभी हम इसमें आगे कुछ कर
That
पाए।
see your conduct. See, you are before this court under Article 226. Your conduct, as is well reflected from the first order, that you have been dodging this authority for more than 4 to 5 occasions. You took time, you avoided to appear. Authority was left with no option than to pass the order. Now authority has decided to pass a complete order as regards the outstanding. Therefore, we will not get into the figure because of your conduct. Nevertheless, we will examine the constitutionality of that provision at a challenge in view of the coordinate bench order. But so far revenue is concerned, you deposit the amount which is found due against you.
Sir, but if your lordship may,
Because of your conduct.
Sir, I can understand, sir. I will seek instructions to that. Right now, I am ready. I have the check of.
No, you may have 2 checks or 1 check. I am not concerned.
Sir, then, sir, what will happen, sir? If I will deposit the whole amount, sir, and they will not permit me to continue, then what will happen, sir? This petition which I have filed challenging their recovery proceedings, because what they have done, they have, like, sir, in the bank, when we make the full of the payment, they initiate some
Since
charges.
you have come to the court of law,
Sir.
any further action of theirs will be always subject to scrutiny by this court.
Sir, but I have only 9 months of continuation, sir. They can take, if your lordship may direct.
Have they cancelled it?
Sir, they have.
They have cancelled. We will see status quo. You will not allot it to anybody, subject to deposit of the amount which is required of you to deposit.
Sir, as per annexure P1, sir, because that is the.
तो जैसा आप कह रहे हैं स्टे कर देंगे उसको, किसी और को वो नहीं दे पाएंगे, आप पहले अमाउंट पे करिए, आगे बात।
Sir, I will just.
P2 is there.
Sir, your lordship may kindly peruse. P1 is the order. He is the authority who can pass the order.
Then
Sir.
we will only issue notice. You pass.
Sir, Sir, P1 is the authority who can pass it. Collector usurping the jurisdiction has made a recovery of more than 1.74
Obviously, whatever is the outstanding, you deposit. We will hear you on the question of constitutionality, and it is also a law that even when the constitutionality is challenged, normally courts does not get accede to the paper entry relief. Normally,
Sir, but in the present matter,
maybe
sir,
that is why we are giving indulgence only on a condition that you deposit the revenue. That revenue law, because of your conduct. If you had behaved properly before the authority, appeared and put your submissions, things would have been different. But you decided not to do it, then flock to the court only on the strength of the division bench order, and then argue that there is a constitutional validity and therefore I am not liable to pay this much, I am only liable to pay this much.
तो कुल मिला के ये है, पेमेंट के मामले में आपको पेमेंट करना चाहिए, और उस वक्त जबकि बुलवाया जा रहा है वहाँ जहाँ मतलब वो कम्युनिकेशन जिस भी तरह का है वो करते रहना चाहिए, अदरवाइज बहुत ज़्यादा नुकसान दे जाता है आगे, क्योंकि 226 में आए हैं ये हाई कोर्ट में सेक्शन में, तो यहाँ कॉन्स्टिट्यूशनलिटी के आधार पे देखा जा रहा है, और एक तरह से वो अपने अधिकार को मांगने आए हैं। जब अपने अधिकार को मांगने आए हैं तो उससे पहले उन्हें अपने दायित्वों का निर्वहन करना पड़ेगा जो उसके आड़े।
This kind of bargaining will not work out in writ court. We have to also follow a judicial discipline, and to our understanding, the discipline requires that if there is an order of the coordinate bench to adjust the constitutionality, we will issue notice, but interim is subject to our discretion, which is based upon the factual matrix in hand. And we have found from seeing the first order that your conduct is not above board and you have been trying to avoid. Therefore, in the fitness of things, first you deposit amount finally found to be due upon you, then we will see.
Sir, may I can take the instructions right away, sir. If your
You
lordship
take
may permit,
instructions,
so that because sir, my only request is if
this amount, see whatever amount you deposit, that will be subject to the final outcome.
and sir, they may be permitted to continue me, sir.
we will say that they will not create third party rights. Then the next time when they come with reply, then we will see your interim application regarding operation.
Sir, they will initiate.
This only
Sir, status quo may be maintained.
That we will say. That we will say. We will say not only status quo, they will not create third party rights, and your interim relief as regards operation of the mine would be considered after they file the reply in
And
2
sir-
weeks time.
And sir, recovery, sir.
Whatever is amount due today,
Sir.
you deposit that amount. We will restrain them from allotting third party, and also call upon them to file reply to your application for continuance, subject to final disposal of the petition on the question of constitutionality.
Sir, I will. Sir, may I mention it at 2:30?
We have miscellaneous benches. You whatever you want to seek, you seek. If you seek this direction, we'll pass the order. Otherwise, we only simply issue notice.
I will just.
Seek instruction, come back. But we will be rising, and you make it fast, because one of this combination may not be available for the whole day.
Sir, that is what I.
तो जज साहब ने कहा फौरन इस मामले में फैसला करिए अगर आप चाहते हैं तो, और आज हम बहुत देर तक नहीं बैठने वाले हैं।
You only have 5 minutes to let us know.
Sir.